Hello everyone. In today's video, we are just going to discuss the AIBE 13 previous year question paper. That is AIBE 13, which was conducted in 2018, 23rd December 2018. We will face 100 question and we will try to solve it and guess the accurate answer of it. So basically, first question says first question says restrictions may not be imposed. This is set A, I guess. Yeah, this is set A. Restrictions may not be imposed on freedom provided under Article 19, Clause 1, Subclause A on this ground. Option defamation, option B public order, option C sedition, option D security of the state. As far as I am aware about it, restrictions में इसका right answer होगा, that is defamation. Restrictions may not be imposed on freedom. Restrictions may not be imposed. Restriction नहीं लगा जा सकता है freedom पे. Under article on this ground. इस पे लगाया जा सकता है. इस पे भी लगाया जा सकता है. सिक्योरिटी ऑफ द स्टेट पे भी लगाया जा सकता है. इसका राइट आंसर होगा ऑप्शन ए डिफेमेशन पे. Because freedom of speech is a fundamental right, but it is subject to reasonable restrictions under Article 19, Clause 2, which includes defamation. Okay, let's see next question. Question number 2. Right guaranteed to citizen only is option A Article 21, option 22 Article 20, option C Article 19 Clause A1 Subclause A, and Article 25. Option D, which is Article 25. Right guaranteed to citizen only. Right guaranteed to citizen only. Article 21, Article 20, Article 21 Clause 1, Article 21 Clause 1 Subclause A, Article 25. Its right option is Article 19 Clause 1 Subclause A. Because the freedom of speech and expression is only available to the citizens only, and Article 21, which is right to life and liberty, is available to all persons. Article 20 protect all persons from self-incrimination, and Article 25 freedom of religion is for both citizens and non-citizens. So its right answer होगा option C, that is Article 19 Clause 1 Subclause A. Question number 3. President can be removed on the ground of option A proved misbehavior, option B incapacity, option C violation of constitution, option D all of the above. Its right option is option D all of the above. Proved misbehavior, so if we will analyze, proved misbehavior is a valid ground. Incapacity includes impeachment, so it is also a valid ground. Violation of constitution is also a valid ground. So all of the above. Question number 4. The designation senior advocates is provided under option A section 16 Advocate Act 1961, option B section 26 same Advocate Act 1961, or under section 6 or under section 15. Its right option is option A, which is under section 16 Advocates Act 1961. So, section 16 basically deals with the classification of advocates into senior and other advocates. Section 26 deals with the disciplinary proceeding. Section 6 deals with the bar council function, bar council function, and section 15 deals with bar council power, bar council power. So its right option is section 16. Section 26 deals with disciplinary proceedings. Section 6 deals with bar council function. Section 15 deals with bar council powers, and what we left section 16, which deals with classification of advocates into senior and other advocates. Question number 5. Right to pre-audience is provided by option A section 33 of Advocate Act, option B, that is section 23 of Advocate Act 1961, option C, section 16 of Advocate Act 1961, or option D, section 36 of Advocates Act 1961. Let me see what section 23 says. Section 33 deals with advocates alone entitled to practice, except as otherwise provided in this Act or in any other law for the time being in force. No person shall, or on after the appointed day, be entitled to practice in any court or before any authority or person unless he is enrolled as an advocate under this Act. What section 23 says? Wait. Right to pre-audience, which is mentioned in section 23. So its right option is option B, that is section 23. Section 23 basically talks about grants, pre-audience rights to senior advocates, and Section 33 deals with who can practice law, who can practice law. Okay, and Section 16 deals with classification of advocates, and 36 talks about the power of disciplinary power basically. Question number 6. The contempt of court belongs to option A, entry 77 of Union list, and entry 14 of state list in the 7th schedule of Constitution of India. Option B, entry 70 of Union list and entry 40 of state list. C, entry 67 of Union list and entry 13 of state list. Option D, none of the above. Its right option is option A, that is entry 77 of Union list and entry 14 of state list in the 7th schedule of the Constitution. Entry 77 of Union and entry 40 of state talks about contempt of court. इसमें एंट्री 67 एंड एंट्री 13 जो है वो बात करता है लॉज ऑन jurisdiction की. Question number 7. Who was the Chief Justice of India when the concept of PIL was introduced to Indian judicial system? Option we have option A, M. Hidayatullah, option B, A. M. Ahmadi, option C, A. S. Anand, option D, P. N. Bhagwati. Its right option is option D, that is P. N. Bhagwati. P. N. Bhagwati. इसमें पीएन भगवती से ऑनरेबल जस्टिस पीएन भगवती से पहले एम हिदायतुल्लाह जो थे प्रैक्टिस में थे एज एन जस्टिस थे. उसके बाद ए एम अहमदी जो थे वो बाद में आए, वो आफ्टर पीएन भगवती के बाद आए. एंड ए एस आनंद जो है ये भी बाद में आए थे. इसका राइट आंसर है पीएन भगवती. क्वेश्चन नंबर 8. द सुप्रीम कोर्ट ऑफ इंडिया issued a number of direction for prevention of women in various forms of prostitution and to rehabilitation their children through various welfare measures as so as to provide them with dignity of person, means of livelihood and socio-economic development in the case of option A, Visakha versus State of Rajasthan, AIR 1997, section 30. Is it a mistake or what? Let's exclude this. So Visakha versus State of Rajasthan, or option B, Gaurav Jain versus Union of India, or option C, Delhi Domestic Working Women Forum versus Union of India, or option D, Sheila Varse versus Union of India in 1986. Its right option is option B, which is Gaurav Jain versus Union of India. So Gaurav Jain versus Union of India, AIR 1997, Supreme Court 3021. Supreme Court 3021. If we talk about Visakha versus the state of Rajasthan, it is related to sexual harassment at workplace. Sexual harassment at workplace. Visakha versus Rajasthan. Gaurav Jain versus Union of India talks about Rehabilitation of prostitutes and their children. Rehabilitation of prostitutes and their children. Delhi Domestic Working Women's Forum versus Union of India talks about um, domestic workers' right, domestic workers' right, and Sheila versus Union of India talks about related to children right in custody, children rights in custody, in custody. So Visakha versus State of Rajasthan talks about sexual harassment at workplace. Gaurav Jain versus Union of India talks about rehabilitation of prostitution and their children. On Delhi Domestic Working Women's Forum versus Union of India talks about domestic workers' right, and Sheila versus Union of India talks about child right in custody. Question 9. Hadith is one of the sources of Muslim law. It comprises option A very words of God, option B words and actions of the Prophet, option C unanimous decision of jurists, option D analogical decisions. Its right option is option B, that is words and action of the Prophet. Hadith refers to the saying and action of Prophet Muhammad. Okay, it is a saying of Prophet Muhammad, and the very words of God is describe Quran, words and action of the Prophet Hadith, unanimous decision of jurist, that is Isma, and analogical decision, that is in Qiyas. Question 10. Intellectual property appellate board is established under which act? Intellectual property appellate board is established under which act? Options we have: the Copyright Act 1957, option B the Patent Act 1970, option C the Trademark Act 1999, option D the Designs Act 2000. Its right option is option C, the Trademark Act 1999. The intellectual property appellate board basically was established under the Trademark Act 1999. The Copyright Act basically deals with copyrights, not with the board. Patent Act is not relevant with the intellectual property appellate board, and Design Acts basically talks governs the industrial design. So its right option is option C, the Trademark Act. Question number 11. That is the maximum duration within which fast track arbitration must be completed. Option B have 6 months, option B 12 months, option C 18 months, option D 24 months. Its right option is option A, that is 6 months. So under section 29A, um, the fast track arbitration must be completed within 6 months. This is 12 months is basically general arbitration timeline, not related with fast track. So 12 months for general arbitration. For fast track arbitration, it should be 6 months, within 6 months, and this is not applicable. Question number 12. Which one of the following section deals with form of summons? Options we have: section 60, section 61, section 62, section 64. Its right option is section B, that is Sorry, the option right option is sorry, right option is B, that is section 61. Okay, so section 61 of CRPC specifies summon formats. Okay, section 60 is related with attachment of property. Attachment of property. Section 61 talks about summon format. Summon format. 62 deals with the service of summon. Services of summon, like how we gonna serve it. And 64 deals with alternative service. Alternative service. So its right answer is option B, that is section 61. Section 61 deals with form of summons. Section 60 attachment of property. Section 60 of CRPC attachment of property. 61 summon format. 62 services of summon, and 64 alternative services. Question number 13. Under CRPC, provisions relating to prosecution of judge is provided under. Question number 13. Under CRPC, provisions relating to prosecution of judgment is provided under. Option A, section 196. Option B, section 197. Section C, 198, or section 199. Its right option is option B, that is section 197. Section 197 basically protects judges from prosecution without prior sanction, and 196 is related to prosecution for sedition. 198 deals with defamation. 199 deals with prosecution for offences against public servants, and 197 already told you protect judges from prosecution without prior sanction. So under CRPC, provision relating to prosecution of judge is provided under option B, section 197. Question number 14. A resides at Hyderabad, B at Calcutta, and C at Delhi. A at Hyderabad, B at Calcutta, and C at Delhi. A, B, C being together at Allahabad, B and C make a joint promissory note payable on demand and deliver to A. A may sue B and C. A may sue B and C at Allahabad, where the cause of action arises, at Calcutta, where B resides. Option C, at Delhi, where C resides. Option D, all of the above. Its right option is option D, all of the above. A can sue at all locations which has been mentioned. Allahabad, because it is valid. Allahabad, it is valid because the cause of action arose here. Calcutta, because the B reside here, as well as Delhi because one party resides here. Question number 15. Section 25 empowers the Supreme Court to transfer any suit, appeal, or other proceeding. Option A, from one high court to another high court. Option B, from one civil court in one state to another civil court in any other state. Option C, both A and B. Option D, only A. 15's right option is option C, that is both A and B. Means Supreme Court can transfer a case from one high court to another high court, from as well as from one civil court of one state to another civil court of any other state. So its right option is option C, that is both A and B. Question 16. In which of the following cases can C set off the claim? In which of the following cases can C set off the claim? Options we have: option A sues C on a bill of exchange for 500. C alleges that A has wrongfully neglected to insure C's good and he is liable to pay compensation. Option B sues C on a bill of exchange for 500 rupees. C holds a decree against A for recovery of debt of rupees 1000. Option C sues B and C for 1000. The debt is due to Calon by A. Option D. A and B sues C for rupees 1000. The debt is due to C by a loan. 16th right option is option B, that is A sues C on a bill of exchange for 500. C holds a degree against A for recovery of debt of rupees 1000. Now question number 17. The Latin word res ipsa lacetur res ipsa lacetur means option A, things speaks its story itself. Option B, where there is consent there is no injury. Option B, both A and B. Option D, none of the above. Its right option is option A, that is things speaks its story itself. ठीक है, इसका राइट ऑप्शन है ऑप्शन ए। बी इसलिए नहीं होगा, बी क्योंकि बी के लिए होता है वॉलेंटी नॉन फिट इंजोरिया। वॉलेंटी नॉन फिट injuria means where there is consent there is no injury. So its right option is option A, that is things speaks its story itself. Res is ipsa lacetur. Question number 18. In which of the following cases the principle of common employment was evolved for the first time? Option A, Rylands versus Fletcher. Option B, Priestley versus Fowler. Option C, Asby versus White. Option D, Wagon versus Mount. 18's right option is option B, that is Priestley versus Fowler. What its explanation says, the doctrine of common employment originally protected employer from liability when one worker injured another. SY versus Y 2700 is a landmark case that discussed the principle of liability in employment and indirectly led to the evolution of the doctrine. Priestley and Flaw discuss employer liability but does not originate the doctrine. Its right option is option A, that is that is sorry, option C, that is SY versus White say. SY versus White say. Why? The doctrine of common employment originally protected employers from liability when one worker injured another. SY versus White 1703 is a landmark case that discussed the principle of liability in employment and indirectly led to the evolution of the doctrine. If we talk about Raylands versus Fletcher, the case deals with strict liability, is not employment. If we talk about Priestley versus Fowler, discusses employer liability but does not originate the doctrine, and Wagon versus Mount deals with remoteness of damage in negligence, not employment law. So it right answer may be SY versus White. Question number 19. Disciplinary committee of Bar Council is conferred the powers of civil court under the Code of Civil Procedure 1908. Option A at Section 36 of Advocates Act 1961. Option B Section 42 of Advocates Act 1961. Option C Section 52 42 42. Option B was 42 of Advocates Act 1961. Option C was Section 42A of Advocates Act 1961. Option D Section 28 of Advocates Act 1961. Its right option is option B, that is Section 42 of Advocates Act 1961. Section 42 of the Advocates Act 1961 gives the Bar Council's disciplinary committee powers equivalent to a civil court under the Code of Civil Procedure 1908. If we will see, the Section 36 deals with the State Bar Council's function, not civil court powers. If we see Section 42A, that provides additional provisions but not directly confers civil court powers. If we see Section 28 relates to State Bar Council elections, not disciplinary powers. So its right answer is answer 42, because Section 42 gives the Bar Council disciplinary committee power equivalent to civil court. Question number 20. Which one of the following is a leading case on injuria sine damnum? Option A. Ryland versus Fletcher. Option B. SY versus White. Option C. Donog versus Stevenson. Stevenson. Option D. All of the above. Its right option is option C. That is Donog versus Stevenson. Sine injuria sine damnum means violation of a legal right without actual damage. So violation of legal right without actual damage. And Donog versus Stevenson 1932 established the concept of negligence, established the concept of negligence and and how a duty of care applies even if no direct damage occurs. If we see Rylands versus Fletcher deals with the strict liability, SY versus White discuss violation of a legal right but not the core of injuria sine damnum, and Donog versus Stevenson basically established the concept of negligence. Question number 21. Which one is leading case on strict liability? Option A, Allen versus Flood. Option B, Raylan versus Fletcher. Option C, Borhill versus Young. Option D, Donog versus Stevenson. 21's right option is option B, that is Raylands versus Fletcher. Raylands versus Fletcher. The case established strict liability where a person keeping hazardous substances is liable even without negligence if damage occurs. Allen, if we see Allen versus Flood, it deals with economic torts, not strict liability. If we see Warhill versus Young, it relates to psychiatric harm, not strict liability. And Donog versus Stevenson deals with negligence, not with strict liability. Question number 22. Section 66A was invalidated by the Supreme Court of India. Section 66A was invalidated by the Supreme Court of India. Options we have option A, Anwar PV versus PK Basir. Option B, Shreya Singhal versus Union of India. Option C, Dr. Prafulla Desai versus State of Maharashtra. Option D, State and City of Delhi versus Navjot Sandhu. Its right option is option B, that is Shreya Singhal versus Union of India. And why so? Shreya Singhal versus Union of India 2015 struck down section 66A of IT, of Information Technology Act, as unconstitutional for violating freedom of speech. For violating freedom of speech under Article 19, Clause 1, Subclause A. If we see Anwar PV versus PK Basir, it it is related to electronic evidence. If we see Dr. Prafulla Desai versus State of Maharashtra discusses telemedicine and video evidence, and State and City of State and City of Delhi versus Navjot Sandhu deals with terrorism charges, not with the IT law. Question number 23. Environmental impact assessment is UA3 under option A, Indian Forest Act, option B, Air Act, option C, Wildlife Protection Act, option D, Environment Protection Act. Its right option is option D, that is Environment Protection Act. Environment Protection Act is a mandatory process under the Environment Protection Act of 1986 to assess environmental impact before starting large projects. Indian Forest Act basically protect forest, but not broad environmental impact. Not focuses on broad environmental impact. Air Act regulates air pollution, and Wildlife Protection Act focuses on animal conservation, conservation. So the right option is Environmental Protection Act. Question number 24. When two or more persons by fighting in a public place disturb the public peace, they are said to be commit option A, a riot, option B, an affray, option C, an assault, option D, none of the above. Its right option is option B, that is an affray. So it is mentioned in section 159 of IPC. Affray occurs when two or more people fight in a public place disturbing public peace. Right basically requires five or more persons, while affray needs only two or more person. Assault involves a threat of violence, but not necessarily a public fight. So, right option is option B, that is an affray and an affray. Question number 25. Promotion of class hatred is given under in promotion of class hatred is given under option A, section 153A of IPC, option B, section 153 double A of IPC, option C, 153B of IPC, option D, section 144A of IPC. Its right option is option A, that is section 153A of IPC. So basically, section 153A IPC punishes promoting enmity between different groups on religious, racial, or other grounds. 153 double A जैसा कोई प्रोविजन है ही नहीं. No such provision basically exists. ABC 153B deals with statements against national integration but not related with class hatred, and section 144A is related to unlawful assembly restrictions. So its right option is option A, section 153A. And so this was the 25 questions, and we will solve the 25 more questions in our next video. Till then, thank you.